or refer to the appropriate standing committee.
Without objection, so ordered. Next order, Mr. Clerk.
Petitions and memorials.
Mr. Clerk.
Mr. Speaker, pursuant to Rule 15, we have a brief statement regarding a petition of remonstrance statement filed by Representative Hulsey. It reads, I'm approaching the Tennessee House Chief Clerk on behalf of Mr. John Gentry with this petition and statement. Involves a petition of grievances. 1, unconstitutional and void statutes. 2, failure to address grievances. 3, judicial reform. 4, reinstitution of constitutionally guaranteed rights. Signed, Bud Hulsey, Tennessee State Representative.
Standing committees designated or held on the clerk's desk. Without objection, the motion to reconsider is hereby tabled. Mr. Clerk.
Unfinished business and notices.
Mr. Clerk.
Mr. Speaker, the constituent of Senator Hale has filed a petition of remonstrance with the clerk's office and is available for inspection by the members.
Thank you. Senator Pody.
Thank you, Mr.
I promise to tell the truth, the whole truth, so help me God. Question: after hearing the whole truth, why would a Williamson County judge only include one side of the story in his opinion and leave out material facts that, if included, would change the outcome? Why? That's what my wife and I want to know. I'm Byron Bush, fighting for judicial reform and a better Tennessee. I need your help.
Next up is item number 8 on your calendar, House Bill 777 by Chairman Ramsey. Chairman Ramsey is wearing his lucky coat for House Bill 777. We have a motion and a second.
Thank you for recognizing. I may need it. We all know this bill essentially addresses an anti-SLAPP piece of legislation. The term SLAPP was generated as a strategic lawsuit against public participation. This terminology was generated in the early 80s. And we're all told, of course, and realize that free speech comes at a cost. A significant number of lawsuits are filed each year in Tennessee that intend to intimidate and silence persons from expressing views and from participating in important matters of their existence, the day, the government. The lawsuits can be extremely expensive to defend, inhibit free speech, and suppress the right to petition government. This bill essentially provides that when a lawsuit is filed against a person, company, or nonprofit based upon their exercise of First Amendment rights involving a matter of public concern, that person or entity may file a petition to dismiss the entire lawsuit or portions of that lawsuit. So what that results in is before we get to the expensive discovery portion of the case, that portion will be postponed until after a court has a chance to make a decision whether the case should be dismissed, avoiding burdensome expenses to the defendant. The United States Supreme Court, of course, has recognized the threat posed by frivolous lawsuits and suppresses free speech, which suppresses free speech for certain individuals, and more than 30 states have already. I'm so used.
Chairman Ramsey, I believe I just heard you renew your motion in ventriloquist fashion.
I stand corrected. I'm sorry. I received so much resistance in most of my legislation that I'm looking for an out. Pending question, sir, I renew my motion.
Members, I realize the question has been called on the bill, and I am at the will of the committee, but I do want to point out there is testimony for and testimony against this bill, folks who have asked to speak, but I am at the will of the committee. So if you would like to, we could, again, the question has been called on the bill, so unless it's withdrawn, we are ready to vote. Okay. Question's been called on the bill without objection. Okay, we do have objection. So we are voting on previous question. All those in favor of previous question would vote aye. All those opposed would vote no. All those in favor of previous question signify by saying aye. Aye. Those opposed? No. Ayes have it. Previous question has passed. All those in favor of sending House Bill 777 to calendar and rules, please signify by saying aye. Aye. Those opposed? No. Aye. The ayes have it, sir. You head to calendar and rules.
Thank you, ladies and gentlemen.
Thank you, sponsor. That brings us to item number...
Senator Dickerson, you're now recognized on item number 7, Senate Bill 1097. You're recognized.
Thank you, Mr. Chairman and committee. I think my writers actually were better for this one, so I hopefully will not engage in excess alliteration. Citizens across Tennessee who are engaged in constitutionally protected exercise of their First Amendment rights have been subjected to frivolous lawsuits aimed at silencing them. These lawsuits are called strategic lawsuits against public participation, or SLAPP lawsuits. SLAPP plaintiffs file complaints to intimidate individuals and groups and deter them from speaking out on public issues. The threat of costly, time-consuming, and expensive litigation tends to silence whistleblowers, journalists, and political protesters. The passage of this bill will protect the right of free speech and defend individuals from frivolous lawsuits. The bill allows for a defendant in a SLAPP lawsuit to file a petition with the court, which may result in the dismissal of the lawsuit before the defendant has to spend thousands or possibly hundreds of thousands of dollars defending the exercise of their First Amendment rights. The bill provides that discovery in the lawsuit will not proceed until the trial judge has examined the pleadings and any affidavits filed by the parties and decide whether the lawsuit has any basis. The bill sets forth standards to be used by the trial judge in making this decision. Further, the bill requires that if the petition is granted, attorney's fees are to be granted, but leaves the judge the leeway to decide the amount of the attorney fees. Imposition of the attorney fees is a critical deterrent. The passage of this bill would cause Tennessee to join more than 30 other states that have adopted such legislation. Here today with me are some of Tennessee's premier First Amendment attorneys to help me answer any questions, and I would defer to the committee if you'd like to go into recess or how you'd like to proceed from here.
Thank you, Mr. Chairman. Let's see if we can get a motion and a second on it first. We have a motion on the bill moved by Senator White. Sir, second. Seconded by Senator Roberts. So we have a motion and a second before us. Members, would you prefer, do you have any questions for the sponsor now, or would you prefer we go into recess to hear from not only people who came to promote the bill, but members of the public who may want to speak against the bill? Okay, without objection, we're going to go into recess. First up, we've got a member of the public who would like to speak on the bill. Mr. Gentry, if you would, please come forward. And Mr. Gentry, there's a way, any of the seats, and make sure your mic is on. No, there's a button you have to push.
Can you hear?
You got you now, and Mr. Gentry. You have 3 minutes, and please keep your comments to the subject of the bill.
Yes, sir. I would ask the members to table or quash this in committee. There is already a mechanism. The attorneys of the body know that under Tennessee Rules of Civil Procedure, Rule 12.02, subparagraph 6, there's already a mechanism to dismiss frivolous lawsuits, failure to state a claim. It's already there. This legislation is directed at persons who exercise constitutionally protected rights, right of petition, right of assembly, and right of free speech. This bill should be the opposite and say a case cannot be dismissed when a person is exercising a right to petition and a right to assemble and a right of free speech. This bill appears to me to be directed at wrongful dismissal. Presently before the bodies is a petition of remonstrance, and I don't want to go off topic with this. In that petition of remonstrance is Appendix L that evidences a member of the Tennessee judiciary.
Mr. Gentry, I'm going to call you out of order. Try to come back to the subject of the bill.
Well,
okay?
12B6 or 12.02 subparagraph 6 is often used to wrongfully dismiss cases. It is already abused as it is. This provides another mechanism to wrongfully dismiss cases. We need to preserve the right of people of Tennessee and of this nation to seek legal action after exercising a right to petition and a right to assemble and a right of free speech. We need to provide them means of redress out of that, and this takes away their opportunity to redress grievance to the court system after they exercise a right of petition, perhaps before the legislature or in assembly elsewhere. So thank you, members, for your time. Please quash this bill in committee. It damages the rights of all citizens. So I would implore you, please don't let this pass.
Okay, Mr. Gentry, just have a seat right there. Let me make sure any of the members, if they have a question for you, if that's all right with you.
Yes, ma'am.
Okay.
I'm happy to answer
Do you
questions.
have any questions for the witness? Senator Bowling, you recognized.
Thank you, Mr. Gentry. It seems as though the inverse of what you are saying the bill does is what the bill does. So you are saying that if someone is exercising their free speech and then someone comes and accuses them of slander or whatever, then the judge will have the right to determine, and I do hear you saying that there's already that right for dismissal, but the judge will be able to say, this is a frivolous lawsuit, that person was exercising their free speech and not slandering or whatever. They were speaking to an issue or to a position. And so it would just seem that the inverse correlation is more accurate than what you're saying.
Mr. Gentry, you're recognized.
Oh, thank you, sir.
Yeah.
Well, again, 12.02 subparagraph 6 already provides the courts mechanisms to dismiss cases. We don't need any more. That Tennessee Rules of Civil Procedure is already abused as it is. My concern with this is so. Let's say a person is wrongfully arrested by a police officer, or they're wrongfully incarcerated by a member of the judiciary, and it's a plain rights violation, and so they petition the General Assembly through petition of remonstrance. And they find that in the case of a judge that judge was misbehaving, and so they toss that whole case out. And the person wants to go back and get justice against that judge. It would take away their ability, because very easily a member of the judiciary would protect another member of the judiciary and just dismiss the case. And it would provide no means. So again, the mechanism's already there to dismiss cases, and this one is specifically targeted at persons exercising free speech, the right to petition, and the right to assemble. I would think that we would want to say that cases can't be dismissed when people are exercising those rights, particularly a right of petition. A right of petition and remonstrance hasn't been used in Tennessee since the year 1850. It's been 170 years, and that just happened in Tennessee. So there's no reason to have the right to petition stated in this bill that's being before the House.
All right. Thank you, Mr. Gentry. Thank you. Seeing no further questions, thank you for being here today. We're just going to stay in recess. I'm sorry. Would y'all like to come forward?
Is there anyone else in opposition to this bill?
No. No. If you would, please.
Are there comments for the sponsor of the legislation? All right, seeing none, we're going to go out of session. Mr. Gentry, you're on the list. If you don't mind coming forward, stating your name and position for the record. And you have 4 minutes, sir.
Is this on? Okay. This bill is clothed in good intentions, but actually it's prima facie evidence of a breakdown in the legal profession and its ability to provide oversight and self-government. The bill is unnecessary and duplicative of existing rules. It's contradictory of existing rules, and it's ambiguous language.
Will you state your name, sir? State your name on the microphone, please.
My name is John Anthony Gentry. The language is ambiguous, and it invites use that is opposite to its intended purpose. It is hostile to justice and to ethical rules by punishing a party who may be a victim of fraud while holding harmless an attorney who is guilty of filing a frivolous lawsuit. how this duplicates existing rules. We already have Rule 12.02, subparagraph 6, failure to state a claim. You can get a case out with that, and judges always stay discovery pending resolution of a 12.026 motion. Rule 11.02, representations to the court. An attorney is certifying to the court that his complaint or any paper, any pleading, is not to harass, that it's not to cause delay or needlessly increase the cost of litigation, and that the claims are warranted by existing law and without frivolous argument. That is a clear representation that an attorney is making when they file a complaint in court. They are certifying that. Now, this has to be true. If an attorney is filing a frivolous suit, that attorney is guilty of malpractice or they are guilty of fraud. Because they are certifying to the court that it is based on warranted or existing law and that it's not frivolous, that's fraud on the court. And it may be fraud on the party because they're representing to their party, yeah, I can win this case, when they know that they don't have a chance in court. So it's fraud on the client to collect attorney fees from the client. We talk about the deterrent, and I heard Senator Dickerson talk about it in the Senate committee. He said that these sanctioning attorney fees is important deterrent. We already have that too. It's in Rule 11.03. 11.30a, if in violation of 11.02, opposing counsel can sanction after providing 21 days advance or opportunity to withdraw or amend the complaint. That's called the safe harbor provision. The purpose of our law is to deter. It is not to punish. And that is how this bill is hostile to justice. It's bent on punishing rather than applying the safe harbor rule. You got 21 days, get it out of there. Now we get down to
60 seconds, sir.
And under this rule 1103B, monetary sanctions may not be awarded against a representative party. So clearly this slap bill is in conflict with 1102 or with 1103 and 1102. And that provides in 1103 that if it is determined to harass or if it is determined frivolous, that the judge can sanction and award attorney fees, and the law firm shall be held jointly responsible. And this gets us to how there's a breakdown in the legal profession, and that's an important phrase in 11023A where it says the law firm shall be held responsible. Tennessee Supreme Court Rule 8, Rules of Professional Conduct, Rule 3.1, a lawyer shall not bring unless after reasonable inquiry the lawyer has a basis in law and fact, and that doing so is not frivolous. It's required by ethical rules of attorneys not to present frivolous lawsuits.
All right, Mr. Gentry, we're going to move on into questions. If you'll stay right there. We got any questions or comments for Mr. Gentry? Chairman Sanderson, you recognize, sir.
Thank you, Mr. Chairman. Mr. Gentry, you heard the testimony or the presentation from the sponsor of the bill, and he contends that this is a bill that we need, and you contend it's not a bill that we need. That puts us in conflict. And so how do we disseminate between what you say and what he says?
You recognize Mr. Gentry.
Well, thank you for asking that, Representative Sanderson. The next point I was going to make is the rules of professional conduct require a lawyer who knows that another lawyer has engaged in misconduct shall report them to the Board of Professional Responsibility. And the same is in Rule 10, Code of Judicial Conduct. A judge that knows of attorney misconduct shall report them to the appropriate authority. So here we have a complete breakdown. We've got an attorney filing a frivolous lawsuit. We've got opposing counsel who is failing to report them for ethical violations, as well as the judge. The whole thing has broken down. If we want to solve frivolous lawsuits, it's not through a slap bill like this. I would encourage, and I would be honored to assist in drafting a bill to properly address this problem. And to do that would be to fine and sanction the attorneys from both sides and the judge who are involved in a frivolous lawsuit that don't report that misconduct to the Judicial Oversight Agency or to the Board of Professional Responsibility. So that's the conflict, is we need to start enforcing the ethical rules and start to heal our nation of the misconduct that's happening in our courts. We don't need legislation that is duplicative and that is contradictory of existing rules.
Thank you, Mr. Gentry. Chairman Sanderson, you recognize.
Yes, and thank you for your response. Are you familiar with any lawsuits that were brought that were frivolous?
Mr. Gentry, you recognized.
I apologize. I'm hard of hearing.
Are you familiar with any lawsuits that that could be interpreted as frivolous? And are we addressing a problem that doesn't need to be addressed? Are we addressing a problem? Obviously, the Chairman Ramsey has seen a need, and so I guess I'm asking you: are you not aware of frivolous lawsuits? And are we addressing something that doesn't need to be addressed?
You recognize.
We have an incredible problem in this country with frivolous lawsuits and false, unsupported allegations. And we need to start enforcing the ethical rules to make sure that stops. Did that answer your question?
Chairman Sanderson. All right. Any other questions or comments for the witness? All right. Seeing none, we're going to go back in session. Thank you for your time, Mr. Gentry.
Thank you, Mr. Chairman.
Back in session.
Thank you, Mr. Chairman. And
you're
82. Vice Chairman Garrett, you're recognized. We have a motion and a second. You're recognized, Chairman Garrett.
Thank you, Mr. Chairman. I would be remiss. I'm going to ask for this to be taken off notice, but I know that my, and pizza's getting cold, my constituent, Mr. Gentry, has been here since we've started this committee, and I don't know, he was confused a little bit about which bill he was on, and I don't know if the committee would indulge, since he's been here this long, to see if he needs to speak on this bill, even though I do plan to take it off notice, but I certainly know he's been here since we've started, which has been a little bit over 3 hours ago. If the committee would indulge me to hear what he has to say, I would appreciate same.
I appreciate that. Mr. Gentry, I think we heard most of your comments. Do you have additional comments? All right. Does anyone have any objection? I hate to do him that way. Certainly, you're welcome. There's no objection to come up and conclude your remarks. Out of session.
So I'm going to recap over what we talked about earlier, just to make sure we're all on the same.
Well, you have 4 minutes.
Yes, sir. So Article 5, Section 1 of the Tennessee Constitution grants the sole power of impeachment to the House. Article 4, Section 6 empowers the legislature to remove judges. And public welfare demands that these protections be returned to the House where they belong, not with the judiciary. In 1822, Governor Carroll, our third governor for Tennessee, he said a well-regulated independent judiciary is so essential to the character of a state that it has a strong claim on your attention at all times. That was to the General Assembly, our third governor, because they had huge problems in the judiciary even back then. Tennessee Constitution, Article 2, Section 3, the powers of the government are divided into 3 distinct branches: legislative, judicial, executive. And under Section 2 of the same article, no person belonging to one of those departments shall exercise powers properly belonging to another. So clearly, in the Constitution, the legislature was empowered to impeach and remove. Those are powers for the legislature. Judicial power is only the power to decide cases at controversy. And the Tennessee Constitution, in Article 6, establishing the judiciary, only grants judicial power. So this responsibility needs to come back to the House. It's also in Article 6, Section 7, a judge shall not hold any office of trust or profit if they're a judge. And being on the Board of Judicial Conduct is absolutely an office of trust, and quite frankly, one that's abused by the Board of Judicial Conduct on a very routine basis. And there's a reason that our framers of our Constitution put into there that they should have no other office. It's because the executive branches would give them an office and have favor, or here, with the judiciary, they're protecting each other very often. That's why they framed it in the Constitution and said they'll have no other office of public trust, because they have so much power as judges. we have a question already before the House questioning the constitutionality. It's been filed in a petition of remonstrance before both houses. We need to answer that question first before we start addressing this one. Since its inception in 1971, Tennessee's judicial oversight agencies have not impeached a single judge. Your first handout is an auditor's compilation report. It's across 18 states. And this auditor's compilation report proves that they dismiss 100% of complaints filed by non-legal professionals. I flagged a section in that report. It's actually Kentucky's report, but it's the same story everywhere. You can see on the chart, they're all filed, majority of the complaints are filed by litigants, and it's due to legal error. It's not legal error. These judges know the law. It's false application of law due to bias or conspiracy to deprive rights very often is what's causing this. That's why we need to protect people by bringing this power back to the House. We recently had Tennessee Judge Casey Moreland was sentenced in federal court. He bribed a police officer $6,000 to plant drugs in the trunk of a car to be discovered in a staged traffic stop. Casey Moreland was diagnosed with mental disorder since 2009. He moved out of his marital home due to infidelity, had alcohol problems, and the Board of Judicial Conduct admitted receiving and dismissing
your 4 minutes are up. Since you've been so courteous today with all we've done, if you'd like to take 1 minute and wrap up, I'll be glad to accommodate you in that regard.
Thank you very much for that, sir. So multiple complaints were received and dismissed against Moreland. In the petition of remonstrance, I've included a complaint that was filed with the Board of Judicial Conduct that was wrongfully dismissed.
Mr. Gentry, if you're not going to address the bill, then I'm going to cut you off. We're not here to try the remonstrance.
We're creating a new judicial oversight agency, the Board of Professional Responsibility now. It has the same function as the Board of Judicial Conduct. And what I'm addressing with these facts is this agency is not doing its job. It's in violation of the separation of powers doctrine. They are exercising powers not granted to them, and they're holding a second office of trust that they shouldn't have. And I'm imploring this committee and the House and the Senate that we need to return this power back to the legislature.
Thank you. Thank you. We went a little over, but with the courtesies that he's shown today, I felt like we owed him that. So thank you. Thank you for your participation. All right, now do we have a motion on the bill? Back in session.
Mr. Chairman, without any objection, I'd like to take that bill off notice.
Off notice. Next, House Bill 670 by Chairman Daniel. Do we have a motion? I'm sorry.
Chairman.
Yes, sir.
I'd like to take that off notice, please.
Off notice. Number 15.